Funding for this program has been provided by the Nevada Rangeland Resources Commission. Congress created the BLM in 1946 with a mandate of managing public lands for a variety of uses, such as energy development, mining, recreation, wildlife sustainability, and livestock grazing under the Taylor Grazing Act of 1934. Currently, the federal government owns over 652 million acres of land, mostly rangeland in the west, and the BLM administers 247 million acres of that. But most Americans are not aware that over the years, the federal government has sold or given away 1/3 of the public lands in the West in water rights, mineral rights, development rights, and grazing rights.
So in the West, in Nevada particularly, most ranches are public lands ranches, which means that a large portion of their grazing lands are public lands belonging to the United States of America, in our case, managed by the Bureau of Land Management.
In the 19th century, manifest destiny was a wildly held belief in the United States, that its settlers were destined to expand and populate all of North America. A stated mission was to redeem and remake the West in the image of agrarian America. Thousands heard the call, and the Western migration began. Early on, however, it became apparent, primarily because of limited rainfall, that the arid West would not support farms the way they were the main source of food in the fertile East. Beef and sheep were to be the logical and main source of protein, and those pioneer ranchers would need government land and water for their livestock herds. The right to graze on the West's vast rangeland was crucial. Federal land policies were enacted to encourage the settlement of the West. Before the U.S. government took a more active role in managing and organizing Western land and water in the early 1800s, settlers came west under the Homestead Act and the Desert Land Entry Act. To those who came under those acts, water rights were easily granted. Our nation struggled with the appropriate role of the federal government in Western expansion. Before statehood, the settlers in each territory, by necessity, developed their own customs, laws, and judicial interpretations concerning water allocation. Their primary solution became known as prior appropriation, and it remains largely intact in Nevada and several other western states today.
I would say of what is considered the 21 western states, I would say probably about 15 of those are also prior appropriation doctrine states. And simply put, it's first in time, first in right. If you made an application to beneficially use water with our office on December 18th, 1942, and you're issued a permit, you're going to be given a priority of that date. So seniority, the priority of the right, is everything. It's king. And so that's what our water law is based on. First in time, first in right.
If we go back to the 1800s, it's the creeks and streams and rivers that were utilized first. What the doctrine of prior appropriation means is that you as a water user may have to watch somebody else's water flow past you. Those laws were adopted in Nevada in 1903, and fundamentally there's been very little changes made to this concept of doctrine of prior appropriation, meaning first in time is first in right, and if you don't use it, you're subject to lose it.
As these territories became states, Congress recognized that each state would be responsible for their own water laws. Congress also recognized that included the water on the public lands located within each state.
The state of Nevada, all of the water belongs to the people, which is unique. It's different than other natural resources in which the state actually owns the resource. For example, wildlife, the state of Nevada owns the elk and the deer, but not so much with water. Water is owned by the people, and it's the state's responsibility to divide that water up amongst the users.
In 1876, the U.S. Supreme Court reinforced an 1866 statute that made the protection of private water rights on public lands official. This ruling effectively conveyed clear title in prior appropriation water rights to private parties and their heirs and assigns forever. In effect, ranchers that could show beneficial use of water even before statehood, their water rights were secured, even on public land. This relinquishment of federal land water rights to private ownership was actually just one of the rights given by Washington. This became known as the split estate or bundle of sticks. In a speech to Congress in 1909, President Theodore Roosevelt proposed that the only logical solution was to create this split estate.
Rights to the surface of the public land must be separated from the rights to the forests upon it and to the minerals beneath it, and these should be subject to separate disposal.
This allowed private individuals to obtain a possessionary right in different bundles of rights or sticks in the public land. Miners obtained mineral rights. Ranchers took water and grazing rights. Other private interests acquired easement rights, development rights, oil and gas, etc. Essentially, this is how ranchers came to own grazing rights and water rights on our rangelands.
The water that we use to water these cattle on this ranch, we do so with the water right that we got from the state of Nevada based on being the priority user, meaning that our cattle were here first or close to first to get that right.
Yet, there is a general perception by many Americans, to this day, that our public lands are owned totally by the federal government, and the people own the land. In fact, while we, the people, through the federal government, own the land, our government has sold or relinquished many of the rights to the use of this land.
The Homestead Act and the Desert Land Entry Act, the Carry Act, were all different ways the federal government had of trying to get land to people who could then use that land to grow crops or develop the land. And so those all related in Nevada particularly to water. The federal requirements were typically, they recognized state sovereignty, if you will, with regard to water. And so the federal government in the Homestead Act and the Carry Act or the Desert Land Entry Act required that adherence to state water law be part of that. And so some of the old Homestead Acts were before the water law, and so they potentially had vested rights.
So vested claims, again, are those beneficial uses of water that predate the water law. There was a bill passed last session that required the filing of vested claims in 10 years. So I think it's by the end of December of 2027. So that's kind of the most recent law change that I'm aware of. And really it is to protect those vested water right holders, because the farther we get away in terms of time frames from those beneficial uses, the harder it is to prove that they beneficially use water. So the legislature said, we need to get all those filed. For anybody out there who hasn't filed them yet, you need to get them filed.
Our approach in managing water rights and in working with public lands users has been that if the rancher has the grazing allotment or a legal basis for being on that land or at that location, that yes, it is an appropriable source, or more frequently, it's a potential legitimate claim of vested right, we certainly feel that there's every right for a rancher to make an application and hold a water right on a spring that's on public land that he uses to serve his operation. Typically, that is grazing.
That doesn't mean the American people have lost their rights to use our public lands. Quite the opposite.
Our allotments that we graze cattle on are part of the multiple use concept, of which we are in favor of. And I think that's what public land is all about. We can use it to graze it. The public can come and they can hunt, fish, recreate. They can look for minerals, should there be minerals. That's another option for public lands, energy development. The multiple use concept, we're in favor of.
But can ranchers' water rights and range rights on public land be as valid as the property rights we enjoy on private land?
I think our grazing preference and our water rights that we have on public lands are very similar to private property held by somebody in a city. There are some differences though, in that it is public lands, and it there is process where those rights could be taken away from us, but they're very similar to any type of private property.
If a rancher sells his ranch, the public land which his private ranch controls is transferred on the same deed as the privately owned ranch and improvements. The federal government recognizes this. Conversely, when a private citizen buys a new home, a deed records the transfer of ownership, and a title search details what they own, including who owns the water rights, utility corridors, easements, etc. The new home buyer recognizes and must agree to who owns these easements and rights on the property he is purchasing.
Water rights in Nevada in particular are a real property that can be bought and sold and need management just like any other piece of property.
The law applies to either public land or private land.
So if you were to buy a public lands ranch from a ranch owner, you would buy the deeded base that they own, that they have a deed for. You would also buy a grazing preference for their public grazing lands from them as well. It wouldn't be from the federal government.
When the owner of private property passes on, an estate tax is levied on those inheriting it. The same is true for a rancher that grazes cattle on Nevada's public land.
When a ranch is in a family and the ranch operator passes on, when he passes that to his heirs, they will not only pay a state tax on the deeded base, they will also pay a state tax on the grazing preference that goes on public lands.
An estate, whether it be a trust or however that estate is handled, the next generation or whoever is in line with the trust to become the next owner is going to have to pay inheritance tax on those BLM or Forest Service permits. And the carrying capacity of the ranch, everything is going to be appraised and have a value put on it. And that government grazing permit is part of that value.
You're given a permit which is allowed by the Taylor Grazing Act. So it's my private allotment and nobody can take it away from me as long as I follow the rules and regulations of the federal government. And but if you want to sell it, you can. So it's a very important asset to any ranching operation.
If federal lands are routinely transferred to a new ranch owner by a private deed of sale, a private property right in the federal land is obviously involved. This concept was reinforced by the Stock Raising Homestead Act of 1916, confirming ranchers own the surface water and grazing rights on their allotments, and why they can buy or sell them. So, just how far do ranchers' ownership rights extend on our BLM-controlled Nevada rangelands?
So Congress did make clear in the Taylor Grazing Act that the grazing permits don't convey a private property right, but this question often gets tied up in the semantics of right versus privilege, and what these permit holders do have is the preference. They're first in line for any grazing that does occur on that land.
It's similar to owning a long-term lease, like on a townhouse in a big city, in that You own that lease, but there is steps that the leaseholder can take to vacate it. And that's my understanding of how it can work with public lands grazing as well.
What happens if the BLM or Forest Service decides to cancel a rancher's grazing permit on his public land allotment? Do they have the right to do that? What happens to the rancher's legal water rights and rights to grazing in that case?
The regulations do provide definitions for a variety of prohibited acts. However, permit revocation is never the first step for any of those things, and it's always the desire to solve the problem without it escalating, which could eventually end up in having repercussions.
If a grazing allotment should be taken away from a permittee for whatever reason, there's a tremendous financial loss, in my opinion, to both parties, because they're the BLM or the forest, whoever is losing a steward of the land. The steward of the land is losing the investment that he's made in that land. Everybody's losing.
Here's the dilemma. The rancher owns the grazing rights and water rights on the allotment under which the grazing permit is issued. If the BLM revokes the permit, are they not then denying the rancher's right to graze the allotment? Are they denying the rancher's right to compensation for property taken under our Constitution's 14th Amendment?
The regulations do provide instruction. In those instances, there's an appraisal process, and depending on things like who paid for the materials and who provided the labor to install the improvement, and then there is a monetary compensation for those losses.
We maintain a lot of water developments and miles and miles and miles of fences, all as part of usually what we refer to as an allotment management plan. And you understand this as a permittee. When you sign that permit, these are your responsibilities. And we understand that. When we sign it, we take on that responsibility. The thing I think that's really important to stress is that there's a tremendous cost that goes with that. Because if anybody knows what vehicles and tires and fuel and all that costs, you add your labor costs and your fence material costs and salt and all this stuff into it, and that becomes a pretty big monthly charge.
I think if it came time where the government thought they should vacate your grazing preference, the rancher should be compensated, because it is a private property that's held, that's taxed, that's bought and sold. And I think if it's vacated for whatever reason by the government, the rancher should be compensated.
This was reinforced in 2007 when a federal district court ruled to protect the historical property interest ranchers own on western rangelands. The judge supported ranchers' rights under the Fifth Amendment, ruling that Congress intended ranchers to have grazing preferences on public land if they could prove historical use of the range and ownership of water rights under local law and custom. Ranchers face many obstacles to maintain their operations. Fire can wipe out their entire allotment, destroying revenue for years. Drought can limit forage availability for livestock. Excessive wild horse populations, often several times over their appropriate management level, can overgraze a rancher's allotment, impacting his own ability to use the resource. In addition, government and environmental regulations often limit a rancher's ability to adapt to changing weather and range conditions year to year. So why do ranchers need to use public land to raise livestock? Successful ranch operations usually include a base privately owned ranch, as well as allotments of public land which add sufficient acreage to make it economically viable. It's not unusual for a western ranch operation to have hundreds of thousands of acres under permit from either the BLM or U.S. Forest Service.
In this part of Nevada, on our ranch, it takes approximately 100 acres to run a cow. So it takes quite a bit of country because of the lack of precipitation that we get. When you figure that Nevada's about 85–90% public lands, we depend on those lands. We can't do it all on private.
Both the BLM and ranchers have been enthusiastic about a new pilot program, outcome-based grazing, that's come down from Washington in 2017.
The outcome-based grazing program is a very exciting initiative that Washington office came out with in 2017. And there's 11 public land ranches throughout the West, 5 of which are in Nevada, that were accepted as demonstration projects for this particular initiative. The whole goal of outcome-based grazing authorizations is to increase the operator's flexibility so that they can be reacting to annual variations in moisture, disasters, wildfire, whatever might occur on the land. They can be reacting to modify operations as the land changes annually.
I'm pretty pleased that BLM is finding new and innovative ways to allow some of those ranchers the flexibility to do those kind of things that we're asking for.
The outcome-based grazing program allows us to develop a project to manage our resources for the different objectives. There's 6 different objectives, one of them being managing for wildlife, for range resources, for managing for the weeds, for fire. That's one of the reasons why we selected this allotment in this ranch, because as you can see from this area out here, this is like the ideal area.
I'm the general manager for Elko Land and Livestock. Elko Land and Livestock is a wholly owned subsidiary of Newmont Mining. We own or operate on about 1 million acres in northern Nevada. Of all the ranches we have, the Horseshoe Ranch is probably in the most deteriorated ecological condition. The ground we're standing on, the allotments have a tendency to burn about every 3 to 5 years. So what's that? And the increase in cheatgrass and the dominance of cheatgrass is what continues to pack that fire return cycle. Years ago when they set the permits in place, they were dealing with a perennial dominated shrub ecosystem. That's changed. We know that's changed. We know the dominance of cheatgrass has increased, and there's hardly any shrubs left in our landscape. And that's problematic to me as a rancher, you as a sportsman, and just as Nevada in general. We've got to have sagebrush in our sagebrush ecosystem to make it function properly.
So do we want to go out in the fall and do some fall grazing, some dormant season grazing to clean up that cheatgrass so that next spring those perennials have a better chance of coming up? What would you want to do out here this fall?
You know, if you could come in here and graze some of this off for about 3 months this fall, I think it'd be extremely worth it. The amount of forage available changes every year. The amount of cheatgrass, the amount of precipitation, the time that it comes changes every year. It was a mistake to think we could put grazing into a box and say you're going to turn 500 cows into this allotment for 7 days or 15 days or whatever it is. As we look, being able to have the flexibility to look at our allotments, know the amount of forage that's available, know the right time and timing, is key to ranchers having success in improving the ecological conditions of rangelands.
We have a targeted grazing program that it's out in the Boulder Valley allotment. This allotment burns every year. It's one of our repeat offenders. We get this burning every year. This year, we developed a program to where they could go out. They had, I think it was over 2,000 head of cattle, and they grazed out there hard and heavy for 3 weeks to clean up a lot of that cheatgrass, and they did trailing, and we had fencing, so where they were confined to this area to hopefully build in that fire break if anything were to break. Well, it did this year. And you can see in some of the pictures, the fire came up through our fire break that we did this targeted grazing on, and it kind of fingered in and stopped. So it was a huge success. We're very excited about it, and that is also one of the projects that we worked with Elko Land and Livestock on.
So being able to take this outcome pilot project, apply the right tools, decrease the amount of fire, increase the grazing, increase the economics of the ranch, increase the ecological resilience, make it sustainable to a society is kind of what this project's all about. The path we see Nevada on at this point, if we keep losing 400,000 acres in each fire and keep doing what we're doing, it's an ecological disaster. Watersheds won't function, rangelands won't function, livestock operators will not continue to be able to be in business. It's hurting all of us.
I guess I'm an optimist. I think we've had some rough patches, as ranchers in Nevada, but I think we're in a pretty good place right now. I think a lot of our agency partners are coming around to our way of thinking about fire rehab and cheatgrass and grazing. And I really think that if our agency partners would have thought less about cow numbers and thought more about time and timing of when we were grazing, back in the days when grazing needed to be done differently, things would have been a lot different here in Nevada. And I think we're kind of all getting to the place where we kind of all understand that and are starting to find ways to move forward with that notion.
I don't know any rancher that does not want a healthy landscape and whatever is best for the land. But they need to be allowed that flexibility to be able to produce that.
The bottom line is that we need a healthy rangeland. Not only the American public that expects that from BLM, but the ranchers that are counting on this land for their livelihood. And they want to be able to have a family ranch that they can pass down to their children. And that's only going to be able to happen if we have healthy rangelands for years to come.
I feel very strongly about the future of ranching, and in my case, family ranching. I think it's really important for everybody to understand that the operations that we run out here benefit a lot of people. We develop the water out there for the cattle and the wildlife. We haul mineral and trace minerals and things that all mammals need. We deliver that out there at no cost to the public. That's for our cattle, wildlife, and anybody, horses, whatever needs that, it's out there available to them. The challenges that we face right now are an increased cost from environmental pressure. That is our number one fear of being able to pass this ranch on from one generation to the other. That's why it's so important for us to run a responsible system on the private lands, the public lands, make a year-round unit out of it. If we're running 12 months a year in a responsible manner, the public benefits just as much as we do.
Funding for this program has been provided by the Nevada Rangeland Resources Commission.